Hi, this is Matt Levy from Patent Progress. In this video, I'll be talking about laws that a number of states have passed to try to deal with the patent troll problem. As of today, 27 states have passed laws against fraudulent demand letters. But because patent law is federal, states are limited in what they can do. Protecting companies from fraudulent or misleading demand letters arguably falls under consumer protection, which is within a state's power. And now that more than half the states have laws to try to deal with patent trolls, they're worth keeping track of. Generally, the laws create a consumer protection offense for sending a demand letter that either omits key information or gives false information. For example, leaving out the number of the patent you claim is infringed, or threatening to sue when you've never actually followed through on the threat could violate a state law. Generally, the laws are similar, but there are variations that different states have adopted. I've listed a few of them here, and now I'll talk about each of these in some more detail. A number of states have adopted a bond requirement. Generally, this provision lets a court order someone who's accused of violating the demand letter law to put up a bond against the other side's expenses and court costs. This bond can be up to $250,000, which can seriously hamper a patent troll that's trying to keep costs down. For example, North Carolina's bond requirement was recently used against a patent troll, and that troll quickly went away. 15 states have a bond requirement of some sort. I've marked those states in blue on this map. The states in red have a patent troll law, but without a bond requirement. Another variation is a private right of action. In every state with a demand letter law, the Attorney General is authorized to take action against the sender. In most, but not all of those states, the recipient of a demand letter can also sue the sender under the law. 21 states have a private right of action. And as before, I've marked those states in blue. Not all states actually limit their laws to letters sent into their states. A number of states' laws are worded so that they could apply if a demand letter is sent from the state. For example, suppose a patent troll sends a fraudulent demand letter from Denver, Colorado to Philadelphia, Pennsylvania. The recipient has no options under Pennsylvania law. But Colorado does have a law that extends to Colorado senders as well as recipients. So in this case, Colorado's Attorney General could take action against the sender. You may remember from the previous map that Colorado does not have a private right of action. There are currently 15 states that have laws that apply to senders as well as recipients. The last variation I'll talk about involves what can trigger the law. In most states, only a demand letter can violate the law. But in some states, filing a lawsuit can also be a violation if the complaint violates the requirements of the statute. Now, this falls into an interesting gray area because the complaint might be good enough under federal law for notice requirements, but still violate a state's patent troll law. This sort of provision might well be preempted by federal patent law, but there's been no test case yet. Only 11 states expand the definition of demand letter to include a complaint. As you can see, state patent troll laws have made the world a bit more interesting. If you've got a demand letter from a patent troll, or if a suit's been filed against you, it's worth checking the states involved to see if they have a law that might apply. For more information on this and other patent topics, keep reading Patent Progress at patentprogress.org and follow us on Twitter. Thanks for watching.